Welcome to the deep dive. Today we're tackling a really fundamental part of the U.S. Constitution, something that, touches on who we are as Americans and what rights we have, the 14th Amendment. You've asked us to dig into its significance, especially with so much discussion around it today, so that's exactly what we're going to do.
Yeah, absolutely. And we have some excellent sources to help us unpack this. We'll be looking at the Wikipedia entry on the 14th Amendment for a solid overview. Also a pretty thought-provoking article from Georgetown Law titled "From Dred Scott to Anchor Babies, White Supremacy and the Contemporary Assault on Birthright Citizenship." And really valuable context from the National Constitution Center on that pivotal Supreme Court case, United States v. Wong Kim Ark.
Okay, so our goal here is to go beyond just the surface of these materials. We want to really understand the core ideas within the 14th Amendment, the historical forces that led to its creation, and, its lasting impact on how we understand citizenship and equal protection. We're particularly interested in the concept of birthright citizenship and want to explore the different ways it's been interpreted and debated. And crucially, we're keeping our focus firmly on the information in these sources, not injecting our own opinions. Okay, let's get into it. What was the spark, really, that led to this amendment in the first place?
Well, the 14th Amendment, adopted back in 1868, was one of the crucial Reconstruction amendments. These came right after the Civil War. It was fundamentally a response to the challenges of integrating formerly enslaved people into American society. And what's striking is that its ratification was actually a prerequisite. Like, the Confederate States had to ratify it to regain their representation in Congress.
Wow. Okay, so that highlights just how contentious and, vital it was seen at the time. It wasn't just a piece of paper that was signed and then forgotten, was it? I mean, the Wikipedia entry makes it clear that the first section of the 14th Amendment has been one of the most frequently argued about parts of the entire Constitution. That tells you a lot about its enduring relevance and impact, right?
Absolutely. And to really grasp why this amendment was so necessary, we need to recall the Civil Rights Act of 1866. This act aimed to guarantee citizenship and equal rights regardless of race. It was effectively overturning those discriminatory black codes popping up in the South, but President Andrew Johnson vetoed it.
Right, and the Georgetown Law article points out Johnson's perspective was that this expansion of citizenship was unfair to the southern states, which, didn't have representation in Congress then. But Congress ultimately overrode that veto.
Exactly. But even with the override, there was still this concern about the long-term constitutional basis for such a law. A future Congress could potentially just repeal it. So this underlying uncertainty is really what fueled the movement to lock these fundamental rights into the Constitution itself through an amendment.
And it wasn't exactly a smooth ride to ratification either. Wikipedia notes that all the former Confederate states, except Tennessee, initially refused to ratify. Why was there such strong resistance there?
Well, these states were largely unwilling to accept the sweeping changes, the changes to the social and political order that the 14th Amendment represented, especially regarding the rights of formerly enslaved people. So this resistance led Congress to pass the Reconstruction Acts, which essentially tied a state's readmission to the Union directly to its ratification of the 14th Amendment.
So federal pressure, basically.
Yeah, it underscores the significant federal pressure involved in getting it passed.
It's interesting looking at which states were first. Connecticut, New Hampshire. Tennessee was actually among the first 28, but then you had states like New Jersey and Oregon that ratified, then tried to withdraw, and then ratified again.
Yeah.
It really speaks to the intense debates and the shifting political ground back then.
Indeed. Now let's dive into the core of the amendment, Section 1. This is where we find those four really pivotal clauses: citizenship, privileges or immunities, due process, and equal protection.
Okay, let's start with the citizenship clause. Given all the current discussions, this seems like a really important place to begin.
It is, absolutely. The clause states directly, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This was a direct, powerful rejection of the Supreme Court's infamous Dred Scott v. Sanford decision from 1857. Which, as both Wikipedia and Georgetown Law highlight, had denied citizenship to anyone descended from African slaves.
So a fundamental correction, basically, overturning a deeply flawed and, discriminatory precedent.
Precisely. And the Georgetown Law article brings out a crucial point. This wasn't just about formerly enslaved people. During the congressional debates around the amendment, there was an explicit rejection of anti-Romani sentiment.
Really?
Yeah. which makes it clear that the principle of birthright citizenship was intended to be broad, protecting the children of all disfavored minorities from being denied citizenship based on their parents' ethnicity or origin.
That's a really significant aspect. I didn't realize that.
It is.
And then we have the Supreme Court case United States v. Wong Kim Ark in 1898. The National Constitution Center has great info on this. This case really solidified our understanding of birthright citizenship, especially for kids born in the U.S. to immigrant parents who weren't citizens themselves. What was the core question?
So Wong Kim Ark, he was born in San Francisco. His parents were Chinese citizens, living in the U.S. but not diplomats or anything. When he came back to the U.S. after a trip to China, they denied him re-entry. They said he wasn't a citizen. Supreme Court, in a 6-2 decision, ultimately sided with Wong Kim Ark. It established that birth within the United States generally confers citizenship under the 14th Amendment with, very specific exceptions, primarily children of diplomats.
But the application wasn't always immediate or universal, was it? Wikipedia mentions Elk v. Wilkins in 1884, and how Native Americans born on reservations weren't initially considered automatic citizens. Why that distinction?
That's a really important point. The court interpreted subject to the jurisdiction thereof in a specific way there. At that time, Native American tribes were often seen as having a separate political existence, almost like domestic dependent nations. So people born into the tribe weren't automatically considered under the full jurisdiction of the U.S. in the same way. But this interpretation evolved through later laws, most notably the Dawes Act in 1887 and then the Indian Citizenship Act of 1924, which explicitly granted citizenship to all Native Americans born within the U.S.
Okay, so that's the citizenship clause defining who is a citizen. What about the next one, the privileges or immunities clause? What protections was that supposed to offer?
Well, this clause was intended to prevent states from infringing upon the fundamental rights of U.S. citizens, rights inherent to national citizenship. But its reach was significantly limited pretty early on by the slaughterhouse cases in 1873. The Supreme Court interpreted it, rather narrowly. They said it primarily protected rights specifically related to federal citizenship, like the right to travel between states, not necessarily a broad shield for all civil liberties against state actions.
Right, so its initial promise maybe didn't quite pan out as broadly as some might have hoped. Let's move to due process. This one sounds incredibly important. It seems to come up in so many legal discussions. What's its core function?
It is absolutely fundamental. It builds on the Fifth Amendment, but the key is it applies to the states, too. It prohibits all levels of government, federal, state, and local, from depriving any person of life, liberty, or property without due process of law. And that covers both substantive due process, the reasons for government action, and procedural due process, the fairness of the procedures used.
And Wikipedia mentions this clause is central to the incorporation doctrine. Can you break that down a bit?
Yeah, think of it like this. The Bill of Rights, those first 10 amendments, originally only restricted the federal government. The incorporation doctrine, working through the 14th Amendment's due process clause, is the legal mechanism that has, over time, made most of those Bill of Rights protections applied to state and local governments, too.
So, like free speech.
Exactly. If the First Amendment stops Congress from restricting your speech, incorporation means your state government can't arbitrarily restrict it either.
And we see the idea of a right to privacy developing from this due process clause too, right? Wikipedia mentions Brandeis and Warren's article.
Precisely. While their article initially focused more on tort law, the Supreme Court later recognized a constitutional right to privacy under the umbrella of substantive due process. Liberty includes privacy. This became a key foundation for huge cases like Griswold v. Connecticut dealing with contraception access,
Right.
Lawrence v. Texas on private consensual sexual conduct, and Obergefell v. Hodges, which legalized same-sex marriage nationwide.
And then more recently, we saw the overturning of Roe v. Wade by Dobbs v. Jackson Women's Health Organization. The source material points out that this decision rested on the argument that a right to abortion wasn't considered, quote, deeply rooted in the nation's history and tradition. How does that relate back to due process?
The Dobbs decision directly analyzed whether a right to abortion could be considered a fundamental right protected by the Due Process Clause's guarantee of liberty. The court concluded it was not, emphasizing that such unenumerated rights must be, as you said, deeply rooted in history and tradition. It really illustrates how the interpretation of liberty under due process continues to be fiercely debated and well redefined.
The Wikipedia excerpt also quotes from United States v. Harris and United States v. Cruikshank. These highlight that the 14th Amendment is primarily a safeguard against state infringement on rights, not necessarily against actions by private citizens. That seems crucial.
It is. These cases are foundational to what's called the state action doctrine. Basically, it says the 14th Amendment's protections kick in when the government is acting, not necessarily when private individuals or businesses act, even if they act discriminatorily. Cases like Shelley v. Kramer involving racially restrictive housing covenants and the civil rights cases further develop this principle.
However, Wikipedia does mention a shift towards a somewhat broader view of state action in the 1960s. What was behind that?
Well, during the civil rights movement, the court started to recognize that sometimes seemingly private actions could become subject to the 14th Amendment if the state was significantly involved or encouraged those actions. Think of like state enforcement of private discrimination. But the court has also set limits. Generally, the state has to have compelled or significantly influenced the private discriminatory conduct for it to count as state action. It's not automatic.
Okay, that leads us neatly to the final part of Section 1, the Equal Protection Clause. On the surface, it seems straightforward, equal treatment under the law. But how has this been interpreted and applied?
At its core, the Equal Protection Clause mandates that each state must provide equal protection under the law to all persons within its jurisdiction. And that all persons part is really important. It includes non-citizens, too, not just citizens. This clause has been the legal engine behind some of the most transformative Supreme Court decisions in American history, challenging all sorts of discrimination.
The Wikipedia entry lists some huge ones. Brown v. Board of Education, Loving v. Virginia,
Right. Ending school segregation, striking down bans on interracial marriage.
Bush v. Gore, Obergefell v. Hodges, and even the recent Students for Fair Admissions v. Harvard case involving affirmative action. What do these really diverse cases tell us about the scope of equal protection?
They highlight just how broad the issues are that this clause touches. From race in Brown and Loving to voting rights in Bush v. Gore, sexual orientation in Obergefell, and affirmative action in Students for Fair Admissions, it's been instrumental in challenging discrimination based on race, ethnicity, gender, sexual orientation, and other classifications. And Wikipedia lists many other cases, too, about residency requirements, alienage, all sorts of things. It shows the ongoing evolution and application of this fundamental guarantee of equality.
So Section 1 really lays the critical groundwork for understanding citizenship, fundamental rights, and equal protection in the U.S. Let's move on to Section 2. This deals with how states are represented in Congress and touches on voting rights.
Yeah, Section 2 fundamentally changed representation by getting rid of the awful 3/5 compromise. Remember, that compromise counted enslaved people as only 3/5 of a person for congressional apportionment. Section 2 said representation would now be based on the total number of adult male citizens in each state.
But there was a catch, wasn't there? Republican leaders at the time were worried. Wikipedia mentions a concern that this change could actually increase the political power of the former slave states, even if they kept stopping black men from voting. How would that work?
Exactly. If the southern states could now count their entire adult male population for representation in the House, but still deny black men the vote, their political power in Congress would actually go up without any expansion of suffrage. Republican leaders saw this as undermining the whole point of Reconstruction.
And initially there was a proposal to reduce a state's representation if it denied voting rights based on race, but that didn't make it through the Senate. Why not?
Well, the more radical Republicans were worried states would just find other ways to disenfranchise black men.
Like we mentioned before, literacy tests, property requirements.
Precisely. Things that weren't explicitly race-based but would have the same effect. So they revised the amendment to penalize states that denied the vote to any male citizen over 21 for any reason other than participation in rebellion or other crime.
Ah, so that covers felony disenfranchisement, but aims for a broader incentive.
Right. It aimed to create a stronger incentive for states to enfranchise black men generally by hitting their representation if they didn't.
And this sort of paved the way for the 15th Amendment later, which explicitly tackled voting rights based on race.
Exactly. Section 2 used the representation mechanism as a kind of, well, a political lever. It was a key step in trying to dismantle the old political structures of the South.
Now, Section 3 deals with who can hold public office. This section has certainly been in the news more recently. What does it say?
This section disqualifies certain individuals from holding federal or state office. Specifically, those who previously took an oath to support the Constitution, like members of Congress or military officers, and then engaged in insurrection or rebellion against the U.S., or gave aid or comfort to its enemies. But it also includes a way out. Congress can remove this disqualification with a 2/3 vote in both the House and the Senate.
And we've seen legal challenges invoking this section, right? Particularly related to the 2024 election and cases involving Scott Perry, Burt Jones. Wikipedia references the Supreme Court's decision in Trump v. Anderson. What was the takeaway there regarding Section
The
3?
Supreme Court ruled unanimously in that case. They decided that states do not have the authority under the Constitution to determine eligibility for federal office based on Section 3. Essentially, they said the enforcement of Section 3 for federal offices, including the presidency, is a power that belongs to Congress, not individual states acting alone.
Interesting, okay. Section 4 addresses public debt and slavery. Seems fairly straightforward.
It is, pretty much. It does two main things. First, it validates the public debt incurred by the U.S., particularly during the Civil War, ensuring the Union's financial stability. Second, and crucially, it explicitly states that neither the federal government nor any state would pay any debt incurred supporting the Confederacy, nor would they pay any claim for the loss or emancipation of enslaved people.
So, slamming the door shut on compensation for former slaveholders.
Absolutely. A clear statement on that.
And finally, Section 5 is the enforcement clause. What power does this give the federal government?
Simple, but powerful. It grants Congress the power to enforce all the other provisions of the 14th Amendment by passing appropriate legislation. Now, as Wikipedia points out, over time, Congress has often relied more on its Commerce Clause power to regulate private conduct related to civil rights. And there's also the anti-commandeering doctrine, which generally limits the feds from forcing states to enact or enforce federal laws. So there are some constraints on this enforcement power.
Okay, so while Section 5 gives Congress the authority, there are evolving interpretations and limitations on how that power is used. Now let's shift focus to the contemporary debates, especially around birthright citizenship. The Georgetown Law article presents a pretty strong argument that it's currently under attack. What's the basis for that claim?
The article argues, that there's a growing movement challenging the long-established understanding of birthright citizenship. And it contends that this movement is often intertwined with ideologies of white supremacy and a desire to maintain, a white majority America. The article traces how certain rhetoric and theories, echoing historical biases against immigrants and minorities, are being used to fuel this challenge today.
It specifically mentions the term anchor baby, which is, a really derogatory term. How does the article connect that to the debate?
As the article highlights, anchor baby is used as a dehumanizing label for children born in the U.S. to undocumented parents. It suggests their birth is just a cynical ploy for immigration benefits. The article connects the use of this term to broader white nationalist and white replacement theories, pointing to rhetoric from figures like Peter Brimelow and Tucker Carlson as examples aligning with these ideas.
And this isn't entirely new, is it? The article draws parallels between these current arguments and older anti-immigrant sentiments, like the fear of a Chinese invasion back in the 19th century.
Yeah, the article emphasizes this recurring pattern, using fear of demographic change, fear of cultural dilution to target specific immigrant groups. Just like the fear-mongering about the Chinese then, similar narratives are used against other immigrant communities now. The underlying theme, the article argues, is often about maintaining a specific racial or ethnic makeup of the nation. The article also mentions an international trend. Some countries, like the UK, Australia, the Dominican Republic, have moved away from unrestricted birthright citizenship, often driven by similar anti-immigrant feelings.
Have there been actual legislative attempts in the U.S. to change birthright citizenship?
Oh, yes. The Georgetown Law article mentions various attempts, like bills introduced by Representative Steve King, aimed at restricting or ending birthright citizenship as we know it. So far, these efforts haven't gained significant traction federally, but the fact they keep popping up shows there's a continued push among some to redefine who counts as a citizen at birth.
Which brings us back to the Supreme Court and the potential for future challenges to Wong Kim Ark, especially with the current court's focus on originalism. What's the concern there, according to the article?
The concern raised in the Georgetown article is that a court focused on originalism, interpreting the Constitution as understood back in 1868, might be more open to revisiting Wong Kim Ark. Arguments that seem settled could be reopened. One specific argument mentioned is the mutual consent theory.
Mutual consent.
Yeah, the idea that citizenship requires not just being born here, but also some kind of consent or acceptance by the nation, perhaps implying the parent's legal status matters more than Wong Kim Ark allowed.
And the article also mentions another potential route, an Article V constitutional convention to amend the Constitution itself. How likely is that, and what are the risks?
Well, it's a constitutionally valid path, but it's complex and, frankly, pretty risky. Some groups do advocate for it to change the citizenship clause. But, as the article points out, there are huge concerns about opening up the entire Constitution to potential changes in today's incredibly polarized political environment.
Yeah, a runaway convention scenario.
Exactly. The risk is it could lead to all sorts of unintended consequences far beyond just birthright citizenship.
So hypothetically, if birthright citizenship were ended in the U.S., what does the Georgetown Law article predict would happen? The consequences sound pretty severe.
The article paints a stark picture. It argues it would lead to a massive exponential increase in the undocumented population. It raises the really serious specter of creating a permanent underclass, a large group of people born and raised here, but denied the basic rights and privileges of citizenship. The article explicitly draws a parallel to the pre-Civil War Dred Scott era, where people were denied rights based purely on their ancestry.
Yeah.
It's a